Thank you very much. It's always a pleasure to be back at Stanford University, even if it is virtually like this time. And thank you to Professor Abbas Milani for his kind invitation to me to share my thoughts on the topic. My talk today is about Iran in the age of imperialism. Iran in the 19th century, an age in which the British and the French extended their rule over Asia and Africa. In the 18th century, they had to retreat from the Americas. So after the US independence, after the independence of Haiti, the British, and to a little bit lesser extent, the French, began their quest to control Africa and Asia. In the course of this quest, most of the native states of Asia lost their independence. Some became protectorates, some were abolished, some were recognized as princely states where the local princes continued administering day-to-day affairs. But in this European expansion, a very small number of states managed to retain their sovereignty. There were a really small group. In Asia, from east to west, we have Japan, China, Siam, which is now called Thailand, Iran. Then there's the Ottoman Empire, a tricontinental state, and in Africa, Ethiopia. This is a very small number. In other words, of the 195 countries in existence today, only 6 are non-Western states that survived the age of imperialism as independent states, if we consider Turkey to be the successor of the Ottoman Empire. And Iran is one of these 6, which gives it a somewhat different type of insertion in the international system. The price these 6 countries, these 6 empires, had to pay for their continued sovereignty was that they had to sign what came to be known as unequal treaties. In other words, treaties that, on the one hand, guaranteed them their continued independence, but on the other hand, limited their sovereignty, because many of the stipulations of these treaties were not reciprocal. That's why we call them unequal treaties. And this has to do with jurisdiction. As European trade was expanding, as more and more British traders went to places like Persia and the Chinese Empire, the Qing Empire in China, the British government and other governments like it were concerned for the safety of these people, also diplomats, missionaries, and so on. And they basically insisted that their subjects in these states, these Asian states, be exempt from the local jurisdiction. Now, if a British subject committed a crime in China, who would judge him? Well, British consular officials. This is why we call this consular jurisdiction. And in the vocabulary of diplomacy, the word capitulation has been used. The capitulations are arrangements whereby citizens of the Western countries are exempt from local jurisdiction in non-Western countries. The reason, or if you prefer, pretext for this being that the non-Western countries do not have codified legal systems and therefore lacked predictability, and the subject of a European power couldn't count on a fair trial in them. Now, in principle, in the beginning, these arrangements were not that inconvenient for Asian states for the simple reason that legal pluralism prevailed in them. In vast empires like China, or even like slightly smaller empires like Persia, different communities, different religious groups, different geographic areas, different provinces, different professional groups had their own rules. There was no, in Iran at least, no national codified legal system. And in the beginning, the idea of giving a group of foreign traders their own rules to live by and to act by could be inserted in the legal pluralism that existed anyway. And it's for that reason that Iranian rulers, beginning with the Ilkhanids, actually granted European traders certain privileges on Iranian territory. This was not seen as an act of subordination. It was part of the legal pluralism that existed in these countries. At times, it was even reciprocal. For instance, in 1708, the last Safavid Shah, Shah Sultan Hussein, signed an agreement with the French state, which called for reciprocal consular jurisdiction. In other words, an Iranian consul in Marseille was given the right to oversee the activities of Iranians in Marseille, these Iranians being mostly Armenians. But the demise of the Safavid dynasty in 1722 put an end to all of this. So how did these unequal arrangements come about? Well, in the Ottoman Empire, it was gradual, in the sense that from generous exemptions granted by the Sultan to foreign traders, they gradually became impositions on the Ottoman state as the power of the Ottoman state vis-a-vis European powers waned. In Iran and China, these arrangements came about as a result of military defeat. And in Japan and Siam, they came about as the result of treaties signed because the Japanese and the Siamese knew and saw what had happened to China and Iran. They didn't want to wait until they were militarily defeated, so they consented to unequal treaties. And since these unequal treaties weren't the result of any wars, they got slightly better terms than the Chinese, Iran, and the Iranians had received. So why do I mention this? Because I want to show that the Iranian case, the place of Iran in the diplomatic world of the 19th century isn't unique. And if Iran had to sign unequal treaties, it was neither a sign of the incompetence of the Qajar rulers, nor a result of their lack of patriotism. It was because they didn't have the strength to stand up to the European powers. Even mighty China, even mighty Japan had to sign these unequal treaties. So in Iran, as most historians of Iran know, the age of unequal treaties begins in 1828 at Turkmenchay, when Iran has to sign a peace treaty with Russia, a peace treaty that ended the Second Russo-Iranian War, and in which the Russians got extraterritorial rights, consular jurisdiction. They received the right to maintain consulates in all parts of Iran where there was Russian trading activity, and these consuls received jurisdiction over Russian subjects. Turkmenchay, the village in Azerbaijan where this treaty was signed, the word Turkmenchay came to symbolize Iranian subordination to more strong powers. And for instance, in 1889, a high-level official, Etemad Saltaneh, when he passes through the village, he looks at the ruins of the house where the treaty had been signed and writes in his diary that this house is where Iran's misfortunes began, So the Russian treaty was soon followed by other treaties for a simple reason. In international law, there's a principle known as the most favored nation. And a country can ask another country to give it the same privileges that it had consented previously to another country. So when Iran had to consent to these privileges to the Russians, soon other countries came and said, we want the same thing. Why do you favor the Russians over us? And the interesting thing is that every time another country made such a demand on Iran, the Iranian government dragged its feet. It's not as though they rolled over and said, okay, we sign. Negotiations would take years until finally they had to give in because the European power was just stronger. And so the second country to sign such a commercial treaty, which gives its subjects privileges in Iran, is Britain. That comes in 1841. And soon in the 1850s, beginning in the 1850s, you have countries like Spain, like Austria, like Belgium, like Prussia, and eventually even the United States signing treaties with Iran, which grant their citizens exemptions from Iranian jurisdiction. Now, why would Iran, which was under no direct pressure from these countries, sign these treaties? The reason was that Iranian diplomacy was trying to find alternatives to the two states that had imperialist designs on Iran, namely Russia in the north and British in the south because of British India. So Iranian diplomacy was always eager to forge ties with other countries in Europe. And the price these other countries extracted for establishing relations with Iran was, again, based on the principle of most favored nation to gain these privileges. One interesting case is the relationship between the Ottoman Empire and Iran. Of course, the Ottoman Empire was in the same situation. They had to sign capitulatory treaties as well. But when the two Muslim states, the two remaining sovereign Muslim states of the 19th century, finally came to make peace in two treaties in the first part of the 19th century, they granted each other extraterritorial jurisdiction. And so this was a case where extraterritorial jurisdiction was actually reciprocal. And this will have a consequence for the eventual abolition of the capitulations in Iran. Now, what does consular jurisdiction mean in practice? It means that if, say, let's take the example of Russians in Iran. If two Russians have a legal dispute, well, without any ambiguity, Russian consular or diplomatic representatives in Iran will look into the matter. If two Iranians have a dispute, obviously it's for the Iranian legal system to look into the matter. The difficulty is if there's a dispute between a Russian and an Iranian. And this has to be dealt with in a way that involves both the Russian and the Iranian legal system. In countries like China and Egypt, a system of mixed courts had been created where you had local judges and judges from the capitulatory powers who jointly would adjudicate a dispute. But the Iranian government always refused to have mixed courts. And they invented a system that, to the best of my knowledge, is unique to Iran, which was a system of cargozars. These cargozars were employees of the foreign ministry stationed in different parts of the country who were responsible for the relationship between foreign traders and the Iranian authorities. So the cargozar had a little court, more an arbitration court than a legal court, actually, where the consul of the foreign trader who was in a dispute with an Iranian trader would be present. And they would try to solve the issue in an amicable way because, again, there was no legal code to go by. Iran had no civil law. So very often this took the form of mediation, arbitration, and to try to come to a solution which would be acceptable to both sides. And one interesting aspect is that the foreign ministry also used these employees, which it had in Shiraz, Mashhad, Tehran, Kermanshah, etc., to keep an eye on the foreigners. So these cargozars had many functions, not only look into legal disputes, but also make sure that the foreigners behave in a way that was acceptable to the government. Where this system became incredibly onerous for Iran was that gradually the capitulatory powers, and they did exactly the same in China, Siam, and the Ottoman Empire, the capitulatory powers extended this rule to locals. In other words, it began when the Treaty of Turkmenchay said that Iranian employees of Russian consulates or the Russian embassy would get the same privileges as the Russian representatives in Iran. But then this was extended, and all sorts of people, usually merchants, would place themselves under the protection of the capitulatory powers. They became known as proteges. This is the protege system, and thereby exempt themselves from the jurisdiction of their own country. And this, of course, was a much more onerous imposition on Iran than the fact that a few hundred British traders in the south would be exempt from Iranian jurisdiction, because these proteges then had an advantage over those of their competitors in the marketplace, which did not have the protection of a foreign power. Their disputes would be looked into by the local cargozars as opposed to the local legal authorities. And as the century moved on, more and more people availed themselves of this opportunity. More and more people became Russian proteges or British proteges. The only way to remedy this situation was, of course, legal reform. What justified the system of capitulations was the absence of a penal code. In traditional Iran, as in traditional China, punishments could be extremely cruel. For instance, in Iran, a person could be tortured in order to get a confession out of him. So obviously, foreign powers didn't want to subject their subjects to these kind of punishments. And it became obvious that for Iran to gain full legal sovereignty, they had to abolish these kind of punishments and adopt a modern or Western legal system. The other thing was commercial codes. If a British trader was owed some money by an Iranian trader, and the Iranian trader said, "I can't pay you back because I'm bankrupt," there were no bankruptcy laws to make sure that the British trader is given what is his due. And so a commercial code was also needed. Not only a penal code, but also a commercial code, registries where you register deed, where you have documents, whereby you can, in a dispute, actually ascertain who owes whom what, and so on. In other words, legal reform became a major, if not the precondition for ending these limitations on Iranian sovereignty, the rule of law. And a big change in the way that modernist Iranians saw these issues came in 1857 after the Iranian defeat in Herat, when Iranian forces were forced by the British to evacuate the emirate of Herat. And at that point, the notion gained strength that what was wrong with Iran was not that there were abuses of the system, but that the system itself had to be changed. And it's at that point that modernists such as Malcolm Khan and Mirza Yusuf Khan and Mustashar Dole introduced the notion of qanun, of law, of a written law, which is internally consistent, which is standardized, which is codified, and without which Iran would not gain the respect of foreign powers. And the interesting thing is that the impetus for this call for legal reform most of the time came from Iranians who had served abroad. Iranians who had served as diplomats in Europe, in Constantinople, in St. Petersburg, and so on. Just to give you an example, in 1867, 1868, the three Iranian representatives in St. Petersburg, Paris, and London send a joint letter to the Persian government in which they argue as follows, quote, "The task whose accomplishment is needed above all else is the establishment of law. Until such time as the legislative and executive powers are separated, it will be impossible for the state and the nation to strengthen the army, extend development, and secure a good name among foreign states." They also called for the abolition of cruel punishments, saying, quote, that they gave the country a bad name abroad. So there were modest attempts at legal reform in the last third of the 19th century, but most of the time these reforms were thwarted. They were thwarted either by the Shah himself, who didn't want to lose too much power, or by conservative forces in society. And the reason is that any legal reform which would put foreigners under Iranian jurisdiction, in other words, abolish the capitulations, would by definition mean legal equality for Muslims and non-Muslims. Because to put British and Russian subjects under Iranian law, you had to give them the same rights as you gave Iranian Muslims, the majority of the population. And this was the sticky point, because conservatives, especially the Shiite clergy, were adamantly opposed to giving Muslims and infidels the same rule under the law. And this was recognized by Malcolm Khan, the great reformer of 19th century Iran, the great reformist intellectual and diplomat, when he observed Japan, where all of this was happening. I mean, the Japanese were busy reforming their laws, giving themselves a constitution. And so in the 1890s, they became the first Asian power to convince the Europeans that the capitulations were no longer needed. And by the early 20th century, they were accepted as an equal by the Europeans. So in 1891, Malcolm Khan lamented, quote, "It is true that the Japanese have copied Europe. There is no such obstacle there as in our case, for their religion is not so strong, but we are prevented from following their example." And what prevents this example is precisely the opposition against equality, not only between Muslim Iranians and non-Muslim Iranians, but also between Muslim Iranians and foreigners. Then we come to the Constitutional Revolution of 1905-1907, and this is the beginning of the codification of law, because when the parliament is constituted, they write a constitution. Following the constitution, different codes are elaborated, and we begin the process of the codification of Iranian law. And in the debates between conservatives and modernists at the Constitutional Revolution, the issue of the rights of non-Muslims is a key one. For instance, Sheikh Fazlullah Nuri, who pleaded for a Sharia-conforming constitution, was livid when an attempt was made to punish the murderer of an Iranian Zoroastrian, for instance. And in response to the modernists' attempt to write laws that would give equality to everybody, at one point he lists the inequalities that exist in Iran. I will quote from that. He pointed out in one of his treatises, a treatise known as Risaleh Tahrim Mashrutiyat, a treatise against constitutionalism. He pointed out that Islam that the Sharia contained all sorts of inequalities between individuals, and he lists them. He says that Islam differentiated between adult and immature, sane and insane, healthy and ill, free agent and desperate, willing and compelled, a person or their agent or guardian, freeborn and slave, father and son, husband and wife, rich and poor, learned and ignorant, doubtful and certain, imitator and source of emulation, descendant of the prophet and commoner, Muslim and infidel, tributary infidel versus hostile infidel, somebody who had, and the final distinctions he makes is between simple apostates and people who had become Muslims and then became apostates again. So he argues that given this, given that the Sharia includes this variety of inequalities, any attempt to create a legal system that gives people equality is actually unacceptable. Nonetheless, the constitutionalists did their best. They came up with certain codes. The legal system was reformed, and so they muddled through. This was an incredibly difficult time in Iranian history. The authority of the central government had disappeared in many parts of the country. In World War I, foreigners fought each other on Iranian territory. Much of the country was occupied by foreign forces. There were warlords in every corner. Law and order had broken down. So it's a miracle that the parliamentarians in Tehran managed to do anything. But they actually did create an embryonic legal system, except even that did not meet the standard of equality. And in his diary, Prince Eno Saltaneh, Nasruddin Shah's youngest brother, noted in 1918 that, I quote, at the present time are overbearing and impudent lawyers who, in spite of engaging in bribery and using 1,000 tricks, cannot bring a case to a close or implement a court order. And here it is important. It is difficult to believe that an Armenian or European who wishes honestly to state his case could get a fair trial. This is as late as 1918. So what the prelude to the abolition of the capitulations in Iran is the fact that in 1914, the Ottomans unilaterally declare that they will no longer be bound by capitulations. And this is, of course, part of their entry into World War I. Germany and Austria voluntarily relinquished their capitulations, and on that basis, the Ottomans wanted to abolish French and British capitulations too. Nothing came of it, of course, because of the outbreak of the Great War. But since the Ottoman Empire and Iran had also capitulatory arrangements, the Iranians argued, well, if the Ottomans abolish the rights we have, we can abolish the rights they have. And so in 1914, Iran declares that they will no longer grant capitulatory rights to Ottoman subjects in Iran, which was an opening for abolishing capitulations elsewhere. The next lucky break that Iran gets, it's the Russian Revolution, the Bolshevik Revolution, where Lenin was very sympathetic to semi-colonial areas like Iran. And the Bolshevik very quickly issued a declaration saying that they're willing to forego all the privileges that Tsarist Russia had imposed on Iran. And later on, in 1921, a treaty is actually signed in which equality between the two sides is enshrined. So given the events in the Ottoman Empire, 1914, and the Bolshevik Revolution in 1917, in July 1918, the Iranian prime minister unilaterally puts an end to the capitulations. And the declaration reads as follows: considering that all the treaties and concessions of Russia were taken by force, that the world's great powers have throughout the war affirmed weak nations' rights to economic and political independence, and that the new government of Russia has declared that it will renounce its privileges, the government declared the abolition of all capitulations. In other words, we cannot grant the British and the French and the Belgians what we no longer have to grant to the Russians. And needless to say, this declaration was totally ignored by the outside powers, because in 1918, the Iranian government hardly controlled Tehran. And so foreign European powers had no incentive to take this seriously. Later, Iran makes an attempt to attend the conference at Versailles, arguing that the country had suffered tremendously. They asked for reparations because the warfare between the Ottomans and the Russians on Iranian territory had obviously caused an awful lot of damage to Iran. Iran had gone through a famine. The Spanish flu had killed 1 million people in 1919. Iran was in terrible shape at the end of World War I. So a delegation is sent to Paris to make these claims at the Versailles Conference, except that the British managed to stop the participation of Iranians, arguing that since Iran had been a neutral country and not a belligerent, it had no business attending a peace conference. However, an Iranian delegation was sent under a very competent diplomat, and the demands made in 1919 outside the conference, sort of in hotel lobbies and in interviews with the press and so on, was precisely the abolition of the capitulations again. So as of 1918, 1919, the Iranian government is on record for trying very hard to abolish the capitulations. Now, the difficulty arose with the Russians because the Russians had voluntarily abandoned their rights in Iran. However, there was no law to govern the disputes between Russian subjects and the Iranians. So there was a case in northern Iran where we are now speaking of the Bolshevik representatives in Iran. In 1920-21, a Russian citizen gets into trouble with the law, and the Russian consul wants to deny the Iranian authorities the right to deal with the issue. And the Iranians say, no, you have yourself renounced these privileges. We are in charge. And so the Russian says, well, yes, I mean, we're happy to give you, to hand this man over, but what are the laws under which this man will actually be tried? And so the Iranians are in a quandary because the establishment of a penal law is running into lots of problems for the conservatives. So at this point, an Iranian lawyer who had returned from Europe with a doctorate in law from Switzerland, Mirza Muhammad Khan Mossadegh al-Saltaneh, who incidentally in 1914 had written a small book on the capitulations in which he had pointed out what needed to be done to abolish them. And in 1914, Mohammad Mossadegh, who of course in 1951 becomes prime minister, in 1914 he was still a young lawyer who argues in this small book that in order to get rid of the capitulations, Iranians had to bite the bullet and grant legal equality to non-Muslims. And he justified that by reference to the principle of expedience, of maslahat. So with the case of this Russian in limbo, Mossadegh is sent to a cleric who is a relatively progressive man who had sympathies with the Constitutionalists, Agha Jamal, and he says, please give us a break, look into the issue, find ways to make equality of rights for non-Muslims compatible with the Sharia on the basis of expediency. The greater good takes precedence over the lesser good, and that sort of thing. Otherwise, we will never gain sovereignty. And the cleric answers with a short and pithy reply. He says, Jahannam. In other words, to hell. To hell with independence. And it's at that point that the legal modernists give up on trying to proceed with the agreement of the ulama. And that's why it's probably not a coincidence that the final legal reforms take place once the dictatorship of Reza Shah has been put in place. because there would have been no way to gain a consensus on these issues. Compromises are made, for instance, in the civil law, the traditional Islamic rules pertaining to birth, inheritance, marriage, divorce, all of these things are enshrined. So Iranian civil law actually incorporates the Sharia. That's why it was not abolished after the revolution in 1979. It was only amended to reinsert inequalities of non-Muslims and Muslims. But the penal law is completely new. So Iran gets a penal law, which is basically an adaptation of European penal law with jail sentences and so on. And this happens in the sort of between 1925 and 1927. And in order to signal Iran's willingness to join the family of law-abiding nations in 1927, in 1926, Iran actually, at the League of Nations, of which it is a member, signs the Anti-Slavery Convention, and 1 year later, slavery is abolished in Iran. So slavery is abolished in Iran in 1927. That was a sine qua non for acceptance as a legal equal. And then in 1928, once all these new legal codes are in place, the government announces that it will unilaterally end the capitulations, and foreign powers no longer make a fuss. This is accepted, and there's a 1 year transition period, and after that, Iran becomes a fully sovereign nation in that foreigners no longer enjoy any extraterritorial rights in Iran. Soon, a case occurred in which all of this could be tested. In 1933, the German director of the National Bank of Iran, Bank Melli, a man by the name of Kurt Lindenblatt, was accused of malpractice, and he was indicted in Iran. This was the first time that a major case was brought against a national of a former capillary power, and the authorities wanted to make sure that the proceedings would be impeccable so as to confirm the view that Iran now abided by international standards of legality. And so the court was made up of one presiding judge and two assessor judges who had all lived in Berlin and spoke German, while Lindenblatt was allowed to be represented by his own German attorney, in addition to two Iranian attorneys, both of whom spoke German as well. He is tried, he is found guilty, but he is given a relatively light sentence. I mean, even the German embassy at the time admits that if he had committed this act in Germany, the sentence would have been stronger. And so the case ended to the satisfaction not only of the German embassy, but also to the Iranian government. And sort of that's how we can say that in 1928, exactly 100 years after Turkmenchay, the capitulary regime ends in Iran. 1 century, I mean, in China, people talk about the century of humiliation, which goes from 1832 to 1843. Unlike China's century of humiliation, the century of humiliation of Iran actually lasted only 100 years, from 1828 to 1928. I thank you for your attention.
Thank you so much, Professor. That was wonderful. We do have several questions coming in, so I'm going to get right to them. A viewer writes, thank you for the informative lecture. Can you please expand on the notion of legal pluralism in Persia prior to 1828 in relation to Western countries' codified legal system?
Yeah, this was not only prior to 1828, this was all through the 19th century. For instance, the religious minorities, Armenians, Jews, Zoroastrians, regulated their internal affairs according to different rules than the Muslims did. You also had a binary system of jurisdiction. On the one hand, you had the Sharia courts, which were presided by a cleric, usually in his own house. There wasn't a court building or anything. The Sharia, the local clerics would register deeds, for instance, of the purchase of a house or a sale of a garden, and so on. But there were also secular courts, which in the language of the Iranian legal system are known as Orfi courts, Orf. And these were under the jurisdiction of the local governor. In Tehran, under the jurisdiction of the Shah; in the provinces, under the local governor, who acted on behalf of the Shah. And this means that there was no distinction between the executive and the legislative branch of the government. Which is something that the legal modernists wanted to establish, because if you have a corrupt governor, who has to look into a trade dispute between two merchants, chances are that the merchant who pays the higher bribe, or who is a distant cousin of a governor, will have an advantage over his competitor and the other person. And it wasn't quite clear which cases would go to the Sharia court and which case would go to the governor's court. In theory, there was a distinction between the two, but in practice, this distinction was very often blurred. In addition, different mujtahids, different clerics, could give different judgments on issues. And this meant that there was quite a bit of what in today's language we would call forum shopping, where the disputants would try to find a forum, this cleric versus the other cleric, the governor versus the cleric, etc., to get a judgment that was to their advantage. And this was precisely why so many Iranians tried to become proteges, because then the presence of a British consul or Russian consul at the cargozar's court meant a certain predictability, at least, made it in their eyes a little bit more likely that they would get a just outcome. And then, of course, the other thing is that Iran wasn't a centralized country, and that you had some little tributary states on the periphery of Iran, the various Arab sheikdoms on the south coast, the Sheikhdom of Bushehr, the Sheikhdom of Muhammara, the Amir of Qa'inat in the eastern part of the country, the Khan of Maku. All these people had their own competencies vis-a-vis their subjects as well.
Thank you, Professor. We have a lot of questions coming in, so I'm going to try to ask as many as we have time for. One viewer says, some Mossadeqists complain that it was he who achieved the equality between Muslims and non-Muslims. Is it correct to understand then that he did not achieve it, but that it was actually Reza Shah who made it happen?
No, it was not Reza Shah who made it happen, because Reza Shah was not a lawyer, and his dictatorship provided the framework where lawyers, real lawyers, people like Mossadegh, people like his son-in-law played a very important role, Ahmad Matin Daftari, wrote laws that did no longer have to meet with the complete agreement of the clergy. I mean, they tried to, write the laws so as to blunt a little bit possible attacks, but in the end, it's the lawyers, foreign educated lawyers, with a few sympathetic members of the clergy together, who wrote Iran's new legal systems. And in fact, one of the major sources for my work on the Capitulations is the doctoral dissertation of Mossadegh's son-in-law, because Mossadegh writes his book on the Capitulations in 1914. Then his son-in-law and close relative Ahmad Matin Daftari goes to Europe and writes in Paris a dissertation on the abolition of the capitulations. And in this dissertation, he writes the kind of obstacles, he writes about the obstacles, the difficulties that the lawyers had in creating this modern legal system. So we have a nice inside account of the compromises they had to make and so on. And this took place in the context of Reza Shah's nascent dictatorship, 1925, 1926, 1927.
Thank you. Another viewer writes, this was wonderful, thank you. Can I ask if and how this is related to economic concessions, most importantly, oil exploration and extraction? Is extraterritoriality relevant to control over lands, minerals, and labor in Khuzestan in the early 1900s?
Not directly, because extraterritoriality consists of treaties signed between governments. It's the Iranian government and the British government and the Russian governments that sign treaties, whereas concessions, very important, like the Reuter concession, the tobacco concession, the oil concession, are treaties signed between the Iranian government and a foreign company or a foreign businessman. And therefore, their legal status is different. Of course, if you are a British businessman angling for a concession in Iran, chances are that British diplomats support you and put pressure on the Iranian government to grant you this concession. But they're not directly related, but of course, there's part of the same syndrome. And the syndrome being the weakness of Iran as a state in the international system, which forces it to sign unequal treaties in order to maintain what little sovereignty they have, and which forces them to sign these concessions. But the other thing one should remember is that from the point of view of the Iranian government, the concessions are not necessarily something bad because they bring in revenue. The Iranian government is broke at this time. So they're constantly looking for ways to raise revenue. And so when a foreign merchant comes in and says, give me the concession for this mine, and in exchange, I will pay the treasury so many £1,000s a year, from the point of view of the government, this is a good deal, because without that business, that businessman, that economic resource wouldn't have been exploited to begin with. So in other words, these foreign concessions and the extraterritorial rights are part of the same syndrome of weakness and underdevelopment, but they're analytically different.
Thank you. Another viewer writes, thank you for the insightful talk. I was wondering what your thoughts are about extraterritorial rights in the Islamic Republic of Iran, for instance, with the current agreement with China and its dispositions about extraterritorial rights for China.
I don't know what these extraterritorial rights are. To the best of my knowledge, the details of the agreement are still not fully known. I obliquely tried to refer to this issue by pointing out at the beginning that Turkmenchay has come to symbolize the subordination of Iran. And so when this agreement, this 25-year agreement with China was announced, people again started talking about a new Turkmenchay. But I'm afraid I don't know enough about the concrete dispositions of this agreement to argue one way or the other. Sorry.
Thank you. Another viewer writes, isn't the diversity of the legal system a form of federalism that ensures local autonomy, i.e. centralized systems are more amenable to dictatorship?
To some extent, yes, absolutely. And it's these are sort of pre-modern checks and balances. In a sense that we think of the pre-constitutional Shahs of Iran, the Fath Ali Shahs, Muhammad Shahs, Nasiruddin Shahs, and so on, as being arbitrary despots who can do what they want to do. That is not quite true. There are checks and balances in the polity, except that they are not constitutionally enshrined. They are just de facto checks and balances, The Shah cannot order and sort of cannot order the head of the Bakhtiari tribe or the Qashqai tribe around. They have, everything is a matter of negotiation and of sort of coming together and seeking consensus between different groups in society, guilds, merchants, clerics, tribal leaders, and so on. But the 19th century is a century of centralization, where the central government in Tehran tries to bring more and more of the country under its control, and it actually succeeds. We very often think of the loss of the territory in the Caucasus, the loss of the territory in Turkmenistan, the inability to conquer the Emirate of Herat, and so on, as elements of diminishing Iranian power. But at the same time, local rulers in Iran are deprived of their power. For instance, the Emirate of Ardalan comes under direct rule of Tehran. Oman controlled large parts of Iran's southern coast. The Omanis are thrown out under the reign of Nasser-ud-Din Shah. Nasser-ud-Din Shah makes a deal with the British to divide Baluchistan. So Iran gets a share of Baluchistan, and the sheikhdom of Bushehr is ended, and the Arab sheikh of Bushehr is thrown out. So in a sense, centralization does take place in Iran. And I think if we want to conceptualize the territorial arrangements in Iran, Iran has to let go of some outer provinces, like Caucasus and so on, like Herat, but in exchange, and at the same time consolidates rule over areas that were under very light central control before.
Thank you. We have just a few minutes left. I'm going to ask maybe two more questions. A viewer writes, you seem to imply that the claims of the colonial powers are legitimate because of the lack of codified laws in places like Iran. Did England have a codified system? Or to ask the same question another way, to what extent was their claim a ruse to hide their hegemony ideas about the superiority of the Western or white cultures?
Both, but the superiority of white culture was very much part of European attitudes to Asian. There's no doubt about that. They felt they are more civilized than the Asians. But what I'm trying to say is that there's a material basis for this view when you look, for instance, at the incredibly cruel way that convicts were executed in Iran. I mean, you don't have to go to British sources. You can find these in Iranian sources, the torturing and so on. The imperialism comes in with trade. In 19th century, British imperialism was a British imperialism of trade. For the British and for the Americans, being civilized meant trading with other nations. That's why Commodore Perry enters Tokyo Bay in 1853 to open up Japan. But once you have that, once you have traders in Iran, you obviously want to make sure that these traders are treated according to standards that they are used to. And Britain, of course, has no civil law, but Britain has common law. And the rule of law was much more centralized in Britain or in France. I mean, France had civil law since Napoleon than elsewhere. In other words, yes, the British could have these attitudes precisely because they were imperialists. But once you accept the reality of imperialism, their demands, I think, became understandable.
Thank you. Last question in the last 2 minutes. We have many comments coming in thanking you for your excellent talk. One viewer writes, how did Western powers look at Persia in comparison to the other 5 countries that survived Western imperialism?
More or less the same. The British, for instance, at one point pressed the Iranians to accept mixed courts. They had pretty good experience with mixed courts in Shanghai, in China, and the Ottoman Empire, and so on. So they wanted mixed courts because these deliberations at the cargozar's office were very often very lengthy and unpredictable. The Iranians always refused that. They wanted to maintain control. In other words, an act of resistance, really, against imperialism. And I think very often the Qajars are insufficiently credited for their resistance against imperialism. And the British didn't press the point. Why didn't they press the point? Because there were simply not enough British traders in Iran. Trade with Iran was much less important than trade with the Ottoman Empire or with Egypt. I mean, the Ottoman Empire and Egypt had long coasts, and on these coasts you had lots of ports in which lots of commercial activity went on. The presence of Iran, of foreign traders in Iran, was not important enough for the British to make a fuss about the absence of mixed ports.
Thank you so much. We've run out of time, but thank you so much, Professor Chehabi. This was a wonderful talk. Thank you to everyone who tuned in. Hopefully the next time we see you will be at Stanford. We wish you all the best, and we'll see everyone next week, hopefully.
Thank you.
Thank you.
Thanks for having me.